It's 5:05 and welcome into a Thursday edition of the Carolina Journal News Hour. News Talk 1110 99.3 WBT. I'm Nick Craig. Good morning to you. We have spent a lot of time over the last couple of weeks discussing tariffs and the various impacts on various industries in North Carolina, whether we're talking about agriculture, technology, steel, some major impacts across the state. We do have a pretty significant update this morning out of the U.S. Court of International Trade. Late in the day yesterday, they blocked a set of steep reciprocal tariffs unilaterally imposed by President Donald Trump on scores of countries in April to correct what the president continues to claim are persistent trade imbalances. The rule does deal a potential serious blow to President Donald Trump's economic agenda and ongoing efforts to negotiate trade deals with various nations. The Supreme Court is very likely to end up having this case sometime later this year, but in the meantime, the Trump administration immediately has appealed the decision to the United States Court of Appeals for the Federal Circuit. In its ruling, a three-judge panel on the Court of International Trade said that the International Emergency Economic Powers Act, which President Trump invoked to impose those tariffs, do not authorize a president to levy universal duties on imports. The judges wrote, quote, "The worldwide and retaliatory tariff order exceeds any authority granted to the president by IEEPA to regulate importation by the means of tariffs, and separate specific tariffs on countries like Canada, Mexico, and China related to drug trafficking, quote, fail because they do not deal with the threats set forth in those orders," according to the panel. Implementing tariffs typically do require congressional approval, but the president chose to bypass Congress by declaring a national economic emergency under IEEPA, which officially became law in the late 1970s, then used the purported emergency as a justification for cutting Congress out of the process and imposing those tariffs again, which we have been talking about pretty regularly over the last couple of months. The panel not only ordered a permanent halt to the tariffs at the issue at some of the countries that we have discussed, but also barred any future modifications to them in the meantime. Now, the Trump administration was given 10 days to make the necessary changes carried out by the judges in their order. Several existing tariffs on specific products like aluminum and steel are not impacted by the ruling yesterday because the president did not invoke that 1977 law to justify their necessary nature. White House spokesperson Kush Desi said in a statement on the ruling, quote, "Foreign countries' non-reciprocal treatment of the United States has fueled America's historic and persistent trade deficits. These deficits have created a national emergency that has decimated American communities, left our workers behind, and weakened our defense industrial base, facts that the court did not dispute. It is not for unelected judges to decide how to properly address a national emergency," said the spokesperson. One of the leading plaintiffs in the case, the Oregon Attorney General, called the ruling a victory not only for his home state, but also for working families, small businesses, and everyday Americans, saying, quote, "President Trump's sweeping tariffs were unlawful, reckless, and economically devastating," saying that the triggered retaliatory measures inflated prices on essential goods and placed an unfair burden on American families, small businesses, and manufacturers. With this, as I just noted just a few minutes ago, this case is likely to make its way all the way to the nation's top court. However, in the meantime, we have this 10-day period in which the Trump administration has the ability to make some of those necessary changes. They are seeking an immediate appeal from the United States Court of Appeals at the Federal Circuit to potentially step in and block the U.S. Court of International Trade that made this decision and made this ruling on yesterday. Could be a big blow for President Donald Trump. If this ends up being revoked, it could be a big blow for some of the businesses that we have continued to cover, again, whether we're talking about the state's largest industry, agriculture, the rising tech sector or so many other businesses and industries across the state that continue to deal with some of the uncertainty as it relates to tariff pressure that they are feeling here across the state of North Carolina. We have a lot of tariff discussion on our website this morning. You can head on over there and read the details over at carolinajournal.com, where it's now 510 News Talk 1110 99.3 WBT. We've been tracking a pretty big political story this week on the Carolina Journal News Hour as it relates to the North Carolina State Board of Elections and recent legal action taken by the United States Department of Justice against the board over some issues with voter registrations in the state of North Carolina. To walk us through some more details this morning, I'd like to welcome Dr. Andy Jackson from the John Locke Foundation back to the Carolina Journal News Hour. Andy, before we get into some of the more pertinent details on this case, can you just give us a broad overview as to why this letter from the Department of Justice came down Tuesday afternoon?
Well, the basic problem is that the North Carolina State Board of Elections hasn't been following federal law for 2 decades. As part of the Help America Vote Act, there is a requirement that every state have electronic voter registration files, and that in those files, they collect either the driver's license number or the social security number for everybody who registers to vote, unless they don't have either of those numbers. And you're looking at a tiny, tiny percentage of the population that doesn't. The State Board of Elections, the way they had designed their voter registration applications, made it seem like that information was optional. So a lot of people, naturally, they don't want to give out any more information than they have to, including those really personal ID numbers. So hundreds of thousands of North Carolina registrants did not. And the State Board of Elections knew officially that they haven't been in compliance for well over a year, but they haven't done anything about it. There's been a series of lawsuits on this, the most famous one being Jefferson Griffin's lawsuit, where he tried to have the ballots from people that had those numbers missing tossed out. The state Supreme Court didn't agree, but the Supreme Court also said that the State Board of Elections had been negligent in their duties and not complying with either federal or state law.
Now, Andy, when we talk about HAVA, the Help Americans Vote Act, we, as you noted, have to go back to 20 years, to the early 2000s when that was passed and came down from Washington, D.C. I'm not an election law expert, but it's pretty clear reading in the HAVA as to what states are required to do for voter registration, especially for some of these digital records. Why? Why was the State Board of Elections in a position where they were not collecting this information as they should have been? The law doesn't seem very ambiguous at all.
The law isn't ambiguous. And if you want to look it up, that's section 303A of the Help America Vote Act. And basically, they had gone through this, nobody had complained. And this kind of happens, unfortunately, a lot, where is you have an early administrative error, nobody raises a fuss about the error, and you just keep on going the way you've been going. And it really didn't start. There was a citizen named Carol Snow who started filing complaint after complaint after complaint to the Board of Elections back in 2023, the State Board of Elections, that, hey, this is a problem. You're not complying with federal law. You're not complying with state law. State law says that election officials have to make a diligent effort. I mean, that's literally written in the law, a diligent effort to get those numbers from people. But county officials and the State Board of Elections, well, we don't have the numbers. Oh, that's too bad. And they just kept on going. And they, at the last of those complaints, they had to finally acknowledge that this was a problem. They fixed the form so that people registering from now on know that this is required information. But under the advice of their general counsel, Paul Cox, he said, you don't really need to follow up and get these numbers from folks that have already registered. And so the state board voted unanimously, Democrats and Republicans, that they weren't going to tell the counties to get that information. And that's how we got in the situation we're in today.
And you bring up this form, and you know, Andy, when you look at the growth in population that North Carolina has seen in the last 20 years, I believe we're only looking, I say about 250,000 voters that don't have this information. That seems like it's a relatively small number as it relates to the boom in population that's happened here in the state over the last 2 decades. Is it strictly because of the ambiguous nature of that form that some people were probably filling out that information, even though it wasn't required, that there's not millions of people that are not registered properly in the state?
Well, there's a couple things. One, yes, the form was a problem, but at some point, there's a voter registration or an election official that looks at that form. They're entering the data, and they see that this required information is blank. What they should have done at that point is reach out to the voter and request that information. And since the state board never issued guidance to the counties requiring that, the county boards were on their own. And so, even individual election officials were on their own. So some would try to get that information, some would not. And that's probably why we are only looking at about 250,000. That's the best estimate that a lot of folks have seen that are missing that information, and not a lot more. And so I think this is a fixable problem. I think they estimated that about 60,000 of those registrants voted in the last election. So you're really looking at that core number that you want to go after first, so that you have correct information on them, and then go to get these other numbers from those other registrants.
We'll continue the discussion with Dr. Andy Jackson from the John Locke Foundation coming up after this. You're listening to the Carolina Journal News Hour. Where it's now 5:16, News Talk 1110, 99.3 WBT. Time to get a look at the roadways on your early Thursday morning commute with Boomer Von Cannon.
Hey, thank you, Nick. Good.
It's 521. Welcome back to the Carolina Journal News Hour. News Talk 1110, 99.3 WBT. Good Thursday morning to you. Well, about 100,000 plus students across the state of North Carolina are set to have an interesting day today due to an outage that took place yesterday that delayed thousands of students from finishing their end-of-grade EOG tests. According to a press release from the North Carolina Department of Public Instruction, a system error caused NC test to not function. That outage lasted about 40 minutes and affected approximately 120,000 students across the state. That NC test program is an online testing system used by the Department of Public Instruction for various standardized tests across North Carolina. Students and families are very much left in limbo this morning as to what is exactly going to happen when their children return to school this morning. According to the state, schools have two options for the test: either resume the test today as to where those students were at a stopping point, or restart the test completely. This is set to be an interesting story we'll track. Obviously, over the last couple of weeks, you've probably heard about PowerSchool, the major school system data provider that had that breach back a couple of months ago. Information technology and information security continues to be a hot-button topic here across the state of North Carolina. We'll track the details right here on the Carolina Journal News Hour, where it's now 523, News Talk 1110, 99.3 WBT. Continuing our discussion with Dr. Andy Jackson from the John Locke Foundation this morning about a very interesting lawsuit filed by the United States Department of Justice against the North Carolina State Board of Elections. Andy, help walk us through some of the timeline here this morning. I know this is something that you've been passionate about for multiple years now. You talk about private citizens that have brought up these complaints. The RNC and the North Carolina Republican Party brought forth legal action in the middle part of last year going after this. This is not something that just popped up earlier this week on the State Board of Election radar.
No, it's not. And as I noted, there were a series of citizen complaints. I'm going to give hats off to Carol Snow again. There are other people that have noted this, but she was the one that was pushing forward these complaints. It got to the point where the State Board of Elections was actually changing their system on how they deal with complaints so that they could have administrative officials deal with it first before it gets kicked up to the board, because they were tired of dealing with her. And so they acknowledged that they weren't following the law. And that kind of set up the lawsuit. So then we had the lawsuit from the RNC, a little bit, several months before the election. Unfortunately, that didn't get dealt with before the election. And there is a rule, especially in federal elections, that you don't make changes in the rules shortly before. There's basically a 90-day window shortly before Election Day. So that lawsuit didn't get past that barrier. Then, of course, we had Jefferson Griffin's lawsuit that came after his protest in December. That stretched out until earlier in May when that was finally resolved. And now we're seeing this one here. So it's been a series of complaints trying to get the state board to do its job and get those numbers.
Well, and I'm glad you bring up the Jefferson Griffin lawsuit. That obviously galvanized a lot of folks across the state of North Carolina. Up until just a couple of weeks ago, it was the last uncontested, uncalled race out of the 2024 general election. Andy, if this stuff had been dealt with, let's say 2 years ago at the State Board of Election level, would Jefferson Griffin have really even had a claim to play out over the last 6 months that we watched?
He would not have. Now, I will say already that the State Board of Elections ruled against Jefferson Griffin back in April. So this didn't even get up to the federal appeal, because there's a precedent. If somebody has a problem with their registration and it's caused by the election officials, not the voters, and that person is otherwise legally eligible to vote, you can't toss their ballot. So, and that's a precedent going back well over 100 years in North Carolina. And so I wasn't expecting Jefferson Griffin to prevail on that question, but it is a legitimate point. Now, would this have changed any votes? Probably very few, if any, but this does raise question about the security of our voter rolls, which raises questions about the security of our elections. And so I think in order to help close that door of doubt, I think they need to go ahead and fix the problem.
Well, let's talk about that. How do we begin the process of fixing this problem? Folks are familiar with the power of the State Board of Elections. The political parties, rather, have just changed. It's now a 3-2 Republican over Democrat majority. There's a brand new election director who, unfortunately for him, has only been on the job a few weeks and then is named in this new federal lawsuit against him. Andy, what does this process look like for the state board to roll out over the next couple of months and, of course, into the very influential midterm elections, which will be taking place next year?
Yeah, well, if you look at the lawsuit wants the state board to develop a plan to start getting that information within 30 days of an order from a judge. So assuming that this thing goes forward and goes through quickly, or if there's a settlement, we're probably going to look at the state board sometime in June, maybe July, issuing guidance to the county boards. Now, the thing is, a lot of these registrations, those numbers exist. They're tucked away in different data files. And this is something that the General Counsel of State Board of Elections now acknowledged back in late 2023, that some of these registrations, they have the numbers, they just haven't matched them with the voter files. So there's a subset where they're just going to have to go through data matching. We don't know exactly how many registrations there are like that, maybe tens of thousands across the state. But the rest, they're going to basically have to tell the county boards to go through the list of registered voters in their county, find the ones that are missing these HAVA numbers, the driver's license or social security number, and start contacting those voters individually. I think they would probably want to prioritize folks that have been voting, that are on the active voter list, get those first, and then go to the folks that haven't voted in the last election, because it's going to be less of an issue if nobody associated with that registration votes. It's a fairly big number, 250,000, but spread across the 100 county boards of elections. I think it's something that they can probably do before the municipal elections this year, and certainly before the midterms.
Well, Andy, you bring up voting, and I kind of find it ironic and rather interesting that the State Board of Elections didn't go through this process in the last election cycle. You talk about 60,000 people that likely showed up and voted that did not either have the last four of a social or their driver's license number on file. Andy, why did the computer not notify those people when they showed up to vote in November that they didn't have this information? The Board of Elections could have collected the data right there. Those people had to show their driver's license to vote.
Yeah, they could have done that. I mean, there's other IDs you can show, but the vast majority of voters show their driver's license. So you would think, like, out of those approximately 60,000, you'd probably get 59,000 if they had this list. And so that's another thing you can do in the municipal elections. One thing, this would require an act from the General Assembly, but you could even, if you want to spice things up a bit, say that anybody who doesn't have these numbers, we will make those ballots provisional until they provide those numbers. That will provide extra incentive for folks to provide that number. But once again, if you've got the list, so you've gone through the first time with the number matching, the data list matching, then step 2, you contact the registrants, and then finally step 3, you reach out to people as they're voting. Those 3 steps together should catch just about everybody, and this will be a fixed problem.
Now, going forward, has that form that we were talking about before that seemed to not really be clear whether the information was required or not, has that officially been resolved? If I move to the state of North Carolina today and go to register and vote, am I going to be required to show that information?
Yes. What they did basically is on the registration forms, if it's in the pink zone, it's required. If it's in the white zone, it's optional. They basically changed the color. They made a small change in the verbiage. So it's pretty clear now to anybody who reads the voter registration application that this is required information. So I really don't expect this to be a problem going forward. And this might be a good thing about this lawsuit. If we do have a settlement or a judgment on this case, this will also inform county boards that, well, even if somebody fails to submit that information, even though it's required, they need to go back and contact that voter to get that information.
A lot of great information this morning. We appreciate the update. Dr. Andy Jackson from the John Locke Foundation joins us on the Carolina Journal News Hour. Where it's now 5:31, News Talk 1110, 99.3 WBT. Time for another look at traffic on your Thursday morning with Boomer Von Cannon.
Hey, thank you, Nick. Good.
WBT is committed to sharing valuable resources about mental and behavioral health. We have partnered with the Mecklenburg County Alcoholic Beverage Control Board to explore this topic of mental illness within families. We welcome two remarkable guests, Miss Unkilun Hamilton Stewart, the Executive Director of Center 360 Incorporated, and Miss Kiuna Simmons, Chief Program Officer at Supporting Housing Communities. If you are interested in learning more and seeking answers about mental illness within the family, we invite you to visit our series, which is on our website this morning over at WBT.com. It's now 5:39. Welcome back to the Carolina Journal News Hour, News Talk 1110, 99.3 WBT. We've got a very interesting story over on our website this morning, carolinajournal.com. The headline, North Carolina appeals courts to hear case involving UNC's possible role in COVID's origins. The state's second highest court will consider a public record lawsuit involving the University of North Carolina at Chapel Hill and its possible role in the origin of COVID-19. A group seeking access to university records filed its opening briefs earlier this week with the North Carolina Court of Appeals. Plaintiffs for the group U.S. Right to Know, which is a nonprofit investigative public health research group, has been investigating the origins of COVID-19 and the virus that it caused, according to court filings throughout the United States. In this case, its investigation led them to request public records from the University of North Carolina at Chapel Hill regarding the work of Dr. Ralph Barrick and his association with the Wuhan Institute of Virology in China. According to the plaintiff's lawyers, quote, the subject matter of this case is of great public interest since more than 1 million American lives have been lost because of COVID-19. The case is also a significant public interest in that the National Institute of Health reports that Dr. Barrick had been awarded grants or other funding for projects and sub-projects in the amount exceeding $200 million since 1986. The request for UNC's public records began in July of 2020, according to court filings, after initially reporting that the requests involved more than 336,000 pages of documents. The university ended up pulling just shy of 87,000 pages in response to requests. The briefing explains defendant, that would be the UNC, that would be Chapel Hill, provided only 6 pages of responsive documentation from a critical time period concerning the origins of COVID-19, namely from March 20th, 2019 to January 9th, 2020. The university withheld pages subject to a research exemption, which is spelled out in North Carolina general statute. The statute reads as follows: research data, records, or information of proprietary nature produced or collected by or for state institutions of higher learning in conduct of commercial, scientific, or technical research where the data, records, or information has not yet been patented, published, or copyrighted is not a public record as defined by general statute. From November 20 through October of 2021, U.S. Right to Know filed half a dozen additional records requests with UNC Chapel Hill involving Dr. Barrick and others. The university continued to cite research exemptions in blocking the release of a vast majority of those documents. The plaintiffs filed suit in April of 2022. Superior Court Judge Allison Adam Green issued an order in October of last year accepting UNC's interpretation of that research exemption. The plaintiffs' lawyers argued, rather than applying the narrowest possible definition to the statute, the trial court instead erroneously applied the broadest possible interpretation of that research exemption. The court filing added that the scheme of the Public Records Act is that records produced by our government with our money and our employees, elected officials or appointed officials, belong to the people. And unless it is absolutely certain that a record should not be produced pursuant to the narrowly defined exemption or exceptions, it must be produced. The proper reading of North Carolina General Statute 116-4317 is that it excludes only research data of a proprietary nature, research records of a proprietary nature, or research information of a proprietary nature, the plaintiffs argued. Treating the word proprietary to be defined as a trade secret is an appropriate and straightforward reading that would have advanced the dual purpose of the legislature to have access to records as broad as possible while reading exclusions as narrowly as possible. They noted that this broad interpretation given by the trial court and the use of the word proprietary, if not completely, causes the exemption to swallow the rule, making almost all university records related in any way to research not subject to public disclosure. Attorneys for U.S. Right to Know wrote, quote, "Given the difficult nature of the statutory scheme of the Public Records Act, that all records are subject to disclosure, and our appellate court's admonishments that exceptions are exemptions to broad statutory languages and are set to be interpreted narrowly, the General Assembly could not have intended to exclude such a vast number of records from the Act's purview. It is much more likely that the General Assembly recognized the competitive nature of scientific research among the nation's universities and simply sought to shield and protect against disclosed information that was akin to a trade secret in a commercial context. Accordingly, the trial court erred in not treating the term proprietary to be synonymous with trade secret, and this court should not hold that most narrow definition to apply to the term." Obviously, this is a very interesting legal saga that we are watching unfold. Carolina Journal reported back in November of 2024 that Dr. Robert Redfield, the former director of the Federal Centers for Disease Control and Prevention, that's the CDC, claimed in a podcast interview that COVID-19 was in fact started at a lab at UNC Chapel Hill. Redfield called Dr. Barrick the scientific mastermind behind that research that is likely many more years before we see any additional details on this and potentially some of these 300,000 plus documents that Chapel Hill apparently has. We'll keep a very close eye on it over on our website, carolinajournal.com, and of course right here on the Carolina Journal News Hour, where it's now 5:46, News Talk 1110, 99.3 WBT. It is time to get another look at the roadways on your Thursday morning with the great Boomer Von Cannon.
Oh, no.
Good morning again. It's 5:52. Welcome back to the Carolina Journal News Hour. News Talk 1110 99.3 WBT. Don't forget that if you miss any portion of our program, weekday mornings 5 to 6 right here on WBT, to check out the podcast. It's available in Google Play, Apple Podcasts, Spotify, anywhere you get your shows. Search for the Carolina Journal News Hour, hit the subscribe or follow button, and you'll get a new program delivered each and every weekday morning. It's the Carolina Journal News Hour podcast. Download and subscribe now. We are tracking a decision out from the United States Court of International Trade late in the day yesterday, actually last night to be more accurate, that blocked steep reciprocal tariffs unilaterally imposed by President Donald Trump on scores of countries in April to correct what the president and his trade advisors continue to say are persistent trade imbalances. The ruling could deal a potential serious blow to President Donald Trump's economic agenda and ongoing effort to negotiate trade deals with various nations. In its ruling, a three-judge panel on the Court of International Trade said that the International Emergency Economic Powers Act, which President Trump invoked to impose those tariffs, does not authorize a president to levy universal duties on imports. The judges wrote, quote, "The worldwide and retaliatory tariff order exceeds any authority granted to the president by IEEPA," that's the Emergency Economic Powers Act, "to regulate importation by the means of tariffs." And separate specific tariffs on Canada, Mexico, and China related to drug trafficking fail because they do not deal with the threats set forth in those order, according to the three-judge panel. Implementing tariffs typically does require congressional approval. However, President Trump chose to bypass Congress by declaring a national economic emergency under IEEPA. That officially became law in 1977 and then used the purported emergency as a justification for cutting Congress out of the process. The panel not only ordered a permanent halt to those tariffs that are in the issue in the case, but also barred any further modifications to them. The Trump administration was given 10 days to make any necessary changes to carry out the judge's order. With that, the Trump administration has also immediately appealed to the United States Court of Appeals for the Federal Circuit. They are seeking an immediate injunction or immediate relief from this ruling. It is likely that the United States Supreme Court could likely end up having the last say in this case, whether under IEEPA or other sorts of congressional authorization, a president of the United States has the ability to impose some of these sweeping tariffs. Several existing tariffs on specific products like aluminum and steel are not impacted by yesterday's ruling because the president did not invoke IEEPA powers to justify their necessity. A White House spokesperson said in a statement on the ruling that, quote, "Foreign countries' non-reciprocal treatment of the United States has fueled America's historic and persistent trade deficits. These deficits have created a national emergency that has decimated American communities, left our workers behind, and weakened our defense industrial base, facts that the court did not dispute. It is not for unelected judges to decide how to properly address a national emergency," end quote there from a White House spokesperson yesterday. One of the lead plaintiffs in the case, Oregon Attorney General Dan Rayfield, called the ruling, quote, "a victory not just for Oregon, but for working families, small businesses, and everyday Americans," noting that President Trump's sweeping tariffs were unlawful, reckless, and economically devastating. The AG in Oregon followed up by saying they triggered retaliatory measures, inflated prices on essential goods, and placed an unfair burden on American families, small businesses, and manufacturers. Yesterday's ruling responded to two separate lawsuits challenging Trump's tariff. One suit was filed by a group of state attorney generals. The other suit was filed by 5 American businesses that heavily rely on goods imported to the United States, which are affected by those tariffs. The 3-judge panel said that in its ruling that the Trump tariffs orders were unlawful as to all, not just to the plaintiffs, meaning that these over these broad tariffs across a vast majority of countries, according to this court, are illegal as we stand here this morning. We'll continue to track the details right here on the Carolina Journal News Hour. That's going to do it for a Thursday edition. WBT News is next, followed by Good Morning BT. We're back with you tomorrow morning, 5 to 6, right here on News Talk 1110 and 99.3 WBT.